Hey, everybody. Just wanted to respond to questions about equitable remedies, and a lot of questions, too. First, real good question was somebody said, why did they unite the equity division and the law division? And I thought, well, I better explain that. Used to be when you were going to file something and ask for an injunction, there were branches of Court of Common Pleas, and I believe the federal courts also had a separate division called equity. And you would file it and note that division of the courts. What was happening was that the cases bounced back and forth between the two, and they really didn't see a reason to keep them separated, so that now they've united it all, and you file a case in Court of Common Pleas or in the federal court, and it all is treated in one court and not switched back and forth. Good question from Holly. When do you seek equitable relief? Usually when you're trying to stop somebody from doing something, usually when it's going on at that moment, and the consequence of what they're going to do has irreparable harm that you can't really fix it. I started to think about things that I've done when I practiced law, and I represented a town, and I had a few temporary restraining orders involving one knocking over a historic house, and the argument was, hey, this is the whatever house, and it was from 1780 or something, and this contractor was going to knock it down, and we thought it was historically significant, so we said, if you knock it down, we can't fix it. So that was a kind of example of irreparable harm. Another time involved a threat to public safety. Again, a contractor doing something with a stream, as I recall, which was going to raise the water level and was impacting a bridge that the town owned. So another sample. Much easier cases where you have irreparable harm sometimes deals with children in domestic relations cases, and I will address those in a moment. I'm just crossing off my things so I don't get too far ahead of myself. With respect to, Pam asked a question about what if the other side doesn't show for a temporary restraining order hearing? It's not uncommon that they don't show. I think I better say that a different way. Sometimes the other side does not appear before the court when you're seeking a temporary restraining order. In some situations, you are calling the court, getting an appointment with a judge, if you can, that afternoon, and then you're required to make an effort to notify the other side. So invariably, a paralegal will file an affidavit along with the other papers that will say, I'm a paralegal employed by whoever. On this date, I contacted by telephone the law offices of whoever and advised that Mr. Freeman would be appearing before the Honorable Judge so-and-so at 4 p.m. at the United States District Court at 6th and Market, or 6th and Arch. So if they don't show, it goes ahead. As long as there will be a question from the court, did you notify your adversary? And usually having called them and told them will be enough. Oftentimes you'll send it by email, as well as it used to be faxing. I don't think that's quite done nearly as much, but that's also done. Nikki asked a good question about irreparable harm, and would psychological harm be a factor in the irreparable harm? Yes, and more commonly, in my experience, children are, and the effect on children is oftentimes given a lot of sway. The cases that I was involved in domestic relations situations involved people, one parent deciding that they're going to take the child to California to live because they really hate it here. No agreement, no talking about it, like grabbing the kids and trying to get them on a plane. And oftentimes we would ask that was considered irreparable harm because the kids would be of a young age, have a close connection to the one parent, and I think you get the idea. For individuals, in other words, if I don't know, if I were the victim, quote, I'm not sure that adults psychological harm is always really that strong a factor, but certainly children get a lot more sway. Cheryl asked a good question about what proof do you actually need. You need an affidavit, and sometimes if you have an expert, in the town cases I told you about, I believe we had an engineer that said that based on their experience, they thought that this would create a threat to public safety and health. So in that situation, that's the kind of proof. You need affidavits to point it out. And if you've got an expert's affidavit, that's even better. In other words, if I were to say a child would face serious psychological harm, I'm not really a psychologist, so oftentimes you might need an affidavit, but preferably an affidavit from someone that has an expert's credentials. Jen asked if there are limits or exceptions to temporary restraining orders. The limits, of course, are that they're only good for 10 days. Exceptions, there are a couple areas where the courts are very, very slow to ever enter an injunction. One would be if I were going to be prosecuted under some law, and I filed a request for a temporary restraining order to stop the criminal proceeding against me. The courts generally do not get involved in that. As a general rule, they don't. There are a couple of exceptions, but they're very rare. I've not seen them, and I don't think many people ever have. Usually you cannot get an injunction against a criminal proceeding. Eileen asked a question about how long between the initial filing of a complaint and a trial. I'm going to give you estimates. Eileen, roughly about 10 months in federal court and about a year and a little more in state court. So if you get your temporary restraining order, only good for 10 days, but if you get a preliminary injunction at the end of your TRO, we're getting cool now, we got all these terms, but if you get a preliminary injunction, remember, which goes from the end of the temporary restraining order to the end of the case, we see what happens. If you win, you get a permanent injunction. But that's a long period of time. Oftentimes, that's really the most important portion of the case. Let's see. A couple people asked, what if you violate a temporary restraining order or a preliminary injunction or a permanent injunction? The court has what are known as contempt powers. They can do all sorts of bad things to you. They can put you in jail until you do something. When I was with legal aid, there would always be people that would ignore court orders, commonly to sign over, in a divorce, sign over a house to the spouse that they've just divorced. Not always their happiest moment. So in those cases, people wouldn't do it. You'd write them a nice note, say, please sign it. They'd say no. So you'd bring them before the court, and the court would hold them in what's known as civil contempt. Civil contempt is, the phrase is that you have the keys to the jail in your pocket, which means you know what you need to do, you can do it, all you have to do is do it, and you get out. In these instances, it was sign over the deed. I saw, honestly, many times where the judge in court would say, are you going to sign this deed, sir? And they'd say no. And the judge would say, okay, take this gentleman to the jail and hold him there until such time as he does sign it. Usually by the time the person had handcuffs on and got to the end of the walkway in the court, they would say, can we go back and see the judge again? And they would have gotten a better idea and would sign that document. So that would happen sometimes. Shamikia asked, is it worse if you violate a temporary restraining order or a permanent injunction? They're all treated the same. They're all contempt, and the court is going to gong you for that stuff. And then with respect to... Miles asked a question about service. Once you get your temporary restraining order signed by the court, you have got to get that order to the other side right away, because until they have been served with it, they don't have any real knowledge of the court's decision. So you can only start threatening people to be held in contempt until they actually know of the order. So you want to get that served right away. I was once involved in a case where my office had to go to the site of picketers and read them the court's order. They said some bad things while we were trying to read that. You know, it was obviously a labor thing and the people weren't happy. They were actually police officers, and they were picketing at a town's landfill. They were picketing over what they felt was a bad labor contract they had, and didn't like the idea that they couldn't block the trash trucks of the town from going to a dump and getting rid of it. It was going to cause a big problem. So that was part of the service upon them all was to send someone to that location and read the order physically to them. They weren't that happy. And let's see. Aisha asked, can you ask for money damages and a temporary or permanent injunction? Yes, you can. You can ask for both. You can alternate them, and most people do. I think Hannah said, what if they turn down your temporary restraining order? Well, the case goes forward, except you don't have the equitable relief. You don't have equitable remedies, but you would have money damages. The court may have decided, well, I understand your claim here, but I don't think there's irreparable harm. There's not harm that can be replaced by money, if you will. Then a couple of good questions, a couple of good observations from both Pam and Alexa, indicating that their offices, or they've seen situations where people always put a wherefore clause at the end of each count. That's, in my opinion, it's smart, but not everybody does it. In fact, I think I may have pointed out your book has some examples where they don't do it. If you have 5 counts in a complaint, one might be fraud, one might be breach of contract, one might be interference with a prospective economic advantage. You may want different forms of relief for each of those counts. So there's plenty of good reason why you'd have separate wherefore clauses at the end of each count, especially if they're going to be different. So that's the answer to that. Also was asked about, Kylene had a question about, can you appeal a temporary restraining order? Yes, you can. Oftentimes in hotly contested cases like the soda tax, I would expect the soda tax will be the subject of an attempt by someone to get an injunction. Let's watch the news and keep an eye on that and see. And basically, it'll be very quick. They'll race in, try and get the tax stopped with an injunction. If they're unsuccessful, I expect they'll have a lot of money and they'll appeal to the next court and see if they can't get an order from that court. So I think that covers your questions. Oh, I think Nicole asked one. What if you didn't have a wherefore clause? They're going to beat you senseless. They're going to throw you out. You got to have a wherefore clause. Otherwise, you're just kidding around. And then David said, can you remove a permanent injunction? I'm not quite sure how, honestly, Dave. I think once it's been entered as a permanent injunction, I'm not sure I see a way that you could have it removed. The question might be if someone got a permanent injunction against you for something and then I came along and was going to do something similar, the lawyer stuff in it would be I'd be trying to show that, yes, they may have gotten a permanent injunction in that case, but this one is different.